Ce matin, comme vous le savez sans doute, nous allons parler de sécurité nationale et les cours fédérales, je suis sûr que vous en êtes tous conscients, sont devenus les principaux tribunaux qui sont chargés d'examiner les questions qui relèvent du droit de la sécurité nationale et du renseignement au Canada. Et c'est un développement, il faut le dire, assez majeur parce qu'il faut se rappeler que dans son livre sur l'histoire des cours fédérales de 1875 à 1992, le professeur Ian Bushnell n'avait fait qu'une brève mention dans son ouvrage des affaires de sécurité nationale. Or, aujourd'hui, vous savez tous que ce sont probablement les affaires les plus célèbres des cours fédérales, ou en tout cas parmi les plus célèbres, et certainement celles qui font le plus souvent la manchette des médias depuis une quinzaine d'années. Je dois dire sur un plan plus personnel que lorsque j'ai été nommé à la Cour fédérale en 2004, je n'avais qu'une très vague idée du rôle de la Cour en cette matière, comme je le soupçonne la plupart de mes collègues au moment de leur nomination. Encore aujourd'hui, je trouve qu'il est frappant de constater à quel point il s'agit d'un domaine méconnu, non seulement dans le grand public, mais même de la plupart des juristes et même presque totalement absent des facultés de droit, sauf peut-être la faculté de Common Law du professeur Craig Fersisi à l'Université d'Ottawa. Et pourtant, les défis sont immenses. Non seulement la technologie évolue à une vitesse fascinante, mais les dilemmes que posent les arbitrages entre la lutte contre le terrorisme et le maintien de la sécurité d'une part, et le respect de la règle du droit et la protection des droits fondamentaux d'autre part, sont de plus en plus complexes. Et je pense que ça vaut la peine à ce stade-ci d'évoquer brièvement la décision que la Cour suprême a rendue dans la première affaire Charkaoui en 2007. Je pense que le passage suivant que je vais vous citer va donner le ton. Alors, je lis ce court passage. L'une des responsabilités les plus fondamentales d'un gouvernement est d'assurer la sécurité de ses citoyens. Pour y parvenir, il peut arriver qu'ils doivent agir sur la foi de renseignements qu'ils ne peuvent divulguer ou détenir des personnes qui constituent une menace pour la sécurité nationale. En revanche, dans une démocratie constitutionnelle, le gouvernement doit agir de manière responsable, en conformité avec la Constitution et les droits et libertés qu'elle garantit. Ces deux propositions illustrent une tension inhérente au système de gouvernance démocratique moderne. Cette tension ne peut être réglée que dans le respect des impératifs à la fois de la sécurité et d'une gouvernance constitutionnelle responsable. Fin de la citation. Alors, bien entendu, c'est d'abord aux représentants élus, avec l'aide des forces de l'ordre, des services de sécurité, de l'appareil gouvernemental, que revient au premier chef la tâche peu enviable de concilier ces impératifs qui peuvent en apparence apparaître irréconciliables. Mais ultimement, c'est au pouvoir judiciaire qu'incombe la responsabilité de voir est-ce que les moyens qui sont retenus pour faire face à la menace terroriste ne portent pas atteinte aux valeurs fondamentales auxquelles les Canadiens adhèrent. Et je pense qu'il est juste de dire que les tribunaux ont initialement fait preuve d'une très grande réticence à intervenir lorsque la sécurité de l'État est en cause, et on l'a vu particulièrement lors des tristement événements d'octobre 1970, où le rôle des tribunaux a été, pour le moins, disons, effacé et peu actif. Mais les choses ont bien changé au cours des 40 dernières années. Et je pense qu'il y a au moins 3 facteurs qui peuvent expliquer ce changement de ton. Le premier, bien entendu, c'est l'entrée en vigueur de la Charte des droits en 1982, qui a donné des outils supplémentaires aux tribunaux. Le deuxième, c'est peut-être l'inspiration que l'on peut tirer de l'expérience étrangère et en particulier de la jurisprudence de plusieurs grandes cours d'autres pays démocratiques qui ont à faire face aux mêmes défis. Mais il y a un autre facteur, il me semble, qui, notamment au sujet, en ce qui concerne les cours fédérales, a joué un rôle important, et c'est, je pense, l'expertise considérable qu'ont acquis les juges désignés au fil des nombreux dossiers dont ils ont eu à traiter au cours des 20 dernières années. Alors, au cours de la prochaine heure et demie, nos conférenciers vont vous faire découvrir et approfondir le rôle important que les cours fédérales ont joué et continueront d'assumer dans ce difficile équilibrage entre le respect de la primauté du droit et la sécurité de l'État, et vous entretiendront surtout des défis auxquels nous aurons à faire face au cours des prochaines années. Alors, dans un premier temps, Mme la juge Catherine Kane de la Cour fédérale fera un rapide survol des origines et des sources de la compétence des cours fédérales en matière de sécurité nationale et s'attardera plus particulièrement à certains aspects de cette compétence, notamment la délivrance des mandats au terme de la loi sur le service canadien du renseignement de la sécurité, au régime juridique qui entoure la divulgation de renseignements susceptibles de constituer une menace pour la sécurité nationale dans une instance judiciaire, ainsi qu'au rôle des cours fédérales en matière d'immigration, notamment au niveau des certificats de sécurité. Madame la juge Kane est extrêmement bien placée pour faire ce survol avec nous, puisqu'elle est l'une des juges désignés de la Cour fédérale, mais surtout qu'elle a œuvré dans le domaine du droit pénal au cours d'une longue et fructueuse carrière au ministère de la Justice du Canada. D'ailleurs, au moment de sa nomination à la Cour fédérale, elle était avocate générale, principale et directrice générale de la section de la politique en matière de droit pénal. Dans un deuxième temps, nous aurons droit à une discussion entre professeur Craig Forsese et maître Gordon Cameron autour de quelques thèmes qui sont, à mon avis, de la plus grande actualité. Ils aborderont notamment le rôle changeant et toujours en expansion des cours fédérales, la multiplication des acteurs dans le domaine de la surveillance et l'évolution de la nature des menaces que l'on cherche à contrer. Le professeur Forsese et maître Cameron sont particulièrement bien placés pour nous entretenir de ces sujets, compte tenu de leur connaissance approfondie et de leur expérience en cette matière. Le professeur Forsese est en effet l'un des plus éminents experts canadiens sur le sujet. Il a beaucoup écrit sur ces questions. Il est entre autres l'auteur du chapitre qui porte sur la sécurité nationale dans le livre publié à l'occasion du 50e anniversaire des cours fédérales, que je vous encourage fortement d'ailleurs à lire. Et il est l'un des co-auteurs d'une monographie, la seule à mon avis, publiée par Irwin Law sur le droit de la sécurité nationale. Quant à Matt Cameron, il a d'abord travaillé à titre d'avocat externe auprès du comité de surveillance des activités de renseignement de sécurité, puis il a agi comme avocat spécial dans certaines causes reliées à des certificats de sécurité, en plus d'avoir été nommé comme ami de la Cour dans plus d'une trentaine de dossiers relatifs à la sécurité nationale, tant devant la Cour fédérale, la Cour d'appel fédérale, la Cour suprême, que dans le cadre de la commission d'enquête sur l'affaire Harand. Alors, je pense que nous sommes en bonne compagnie. Je laisse donc sans plus tarder la parole à Mme la juge Kane. Je précise, avant de terminer, que si vous avez des questions, il nous fera plaisir d'en prendre connaissance et de les poser directement au conférencier ou plutôt de vous laisser le soin de le faire à la fin des présentations. Alors, Mme la juge Kane, à votre tour.
Bonjour, je suis heureuse de faire partie du panel aujourd'hui pour discuter du travail de la Cour fédérale sur les questions de sécurité nationale. Mon aperçu d'aujourd'hui n'est que cela, un aperçu pour fournir le contexte des présentations et des discussions qui suivront. Les diapositives sont fournies à titre de référence et je ne ferai pas référence à toutes les informations contenues dans celles-ci. Comme vous le comprendrez, je ne peux pas fournir d'anecdotes sur des cas particuliers ou des exemples, autres que des hypothèses, compte tenu de la nature du travail. Par conséquent, je m'excuse d'avance pour une présentation un peu aride sur un domaine de droit qui est fascinant et aussi troublant et peut-être mal compris, mais très important. I should also note that because this is a general overview, the simplicity may overlook some important details that are highlighted in the legislation and the jurisprudence. Just a word again about the slides. Although they bear my name, these slides were developed by my colleague, Justice Mosley, a few years ago for the purpose of a presentation to our incoming clerks, and these have been updated. By way of history, there have been several key turning points in the evolution of the role of the federal court in national security. In the 1970s, the RCMP Security Service was the key player in matters of national security. And even though a police service, they obtained warrants for electronic interception for national security purposes from the then Solicitor General and not from a judge. The MacDonald Commission, established in 1977, was mandated to explore the adequacy of Canada's laws regarding national security. It produced 3 reports between 1979 and 1981, and the implementation of many of the recommendations changed the landscape. The Commission made several recommendations, including that warrants for national security purposes be made to a judge of the federal court and be carefully scrutinized in a similar manner to other judicially authorized interceptions. It also recommended that a civilian security agency be established, and CSIS was born as a result. The threat environment has changed drastically from what may have been contemplated in the 70s and 80s, and technological changes have created both opportunities and challenges. The public's awareness of national security issues has also increased greatly, and the techniques to gather information about threats to national security have evolved. Asserting that a matter engages national security does not open the door to violations of other rights. The Charter remains at the forefront, and the Court is alive to the need to ensure that the intrusion on Charter rights to protect the country from national security-related threats is carefully balanced and minimized. As Justice de Montigny noted, there are several sources for the Court's national security jurisdiction, and I will highlight only a few. To borrow Professor Forsizi's terms, the Court has both a regular jurisdiction and a specialized national security jurisdiction. The regular jurisdiction includes, for example, the judicial review of a decision of a board or a tribunal where some aspect raises an issue of national security or the need to protect information, such as the judicial review of a decision to deny a security clearance or to refuse to provide personal records to a requester based on exemptions claimed in the Access to Information Act. The specialized jurisdiction is that set out in the various statutes that over the years have expanded and refined the role of designated judges of this court. For example, the judicial review of a security certificate or the appeal of a decision to refuse to delist a person on the no-fly list. These statutes include the Canada Evidence Act, the Immigration and Refugee Protection Act, the Canadian Security Intelligence Service Act, Secure Air Travel Act, Prevention of Terrorist Travel Act, the Access to Information Act, and several others, all of which require that certain applications or matters be determined by a designated judge. So what do we mean by designated proceedings? The definition is a bit circular. It simply means proceedings that must be dealt with by a designated judge based on the respective statute that give us and only us the jurisdiction. But it's more than just designated the judge. In our space for designated proceedings, which we refer to as the bunker, we have a highly secure environment with courtrooms, offices for the judges, an amicus, and a team of designated registry officers along with counsel. We provide secure storage facility for the files. We have an internal computer network that is not connected to any other networks. No electronic devices are permitted to enter the space. The registry staff, the amici, the special advocates, law clerks, counsel, and affiants who enter the bunker all have security clearances and are subject to the Security of Information Act. Every measure is taken to ensure that protected information remains protected. There are currently 13 designated judges, and we provide 24-hour-a-day, 7-day-a-week accessibility. Designated judges meet from time to time as a group to discuss emerging issues and to share information about trends, also to learn about new technologies. And where we have presentations about new technologies, we always ensure that there is a neutral person or persons present, for example, a retired judge from another court, who acts as a buffer, given that the presentations may be made by CSIS personnel who would be appearing before us in other proceedings, sometimes ex parte. Occasionally, designated judges sit en banc as a group of 3 or more, for example, to hear technical evidence in a particular case that will have implications for other cases or regarding cross-cutting legal issues. But our independence remains, and one judge would decide the particular application. The issuance of warrants pursuant to the CSIS Act is a large part of our work. CSIS has 2 key mandates. The core mandate is set out in Section 12 to collect, analyze, and retain information and intelligence respecting the threats to the security of Canada. And amendments to the CSIS Act in 2015 clarified that there is no territorial limitation on the jurisdiction to investigate threats to the security of Canada. The second mandate is set out in Section 16, and it relates to the defense of Canada and the conduct of its international affairs. Under Section 16, CSIS may assist the Minister of National Defense and the Minister of Foreign Affairs, but only within Canada, in the collection of information relating to the capabilities, intentions, or activities of any foreign state or any person other than a Canadian citizen, permanent resident, or Canadian corporation. To obtain a judicial authorization, in other words, a warrant, the requirements of Section 21 of the Act must be met. Among other things, the application for the warrant and the affidavit and the affiant who appears must set out that a threat to national security is present and the nature of that threat, what justifies the belief that a warrant is required, and what other means to gather that information have been tried without success. There is a distinction between the warrants granted pursuant to the CSIS Act and criminal code warrants. As noted, CSIS is a civilian agency. It is not law enforcement, but it would not make any sense for CSIS to gather information about possible threats and not be able to do anything about it. So CSIS is authorized to disclose certain information to law enforcement in accordance with the CSIS Act at Section 19, or as applicable to the Minister of Foreign Affairs or the Minister of National Defense. Applications pursuant to the Canada Evidence Act are also determined by designated judges. Where the Attorney General of Canada is of the view that sensitive information, as that term is defined, is about to be disclosed before any court, Section 38 of the Canada Evidence Act may be relied on by the Attorney General. The issue of disclosure of that information will then land in the federal court to be determined by a designated judge. And as a result, the proceedings in the other court may need to be adjourned pending that determination. This arises in several ways. For example, in a criminal proceeding where disclosure must be provided to an accused person, yet some of the disclosure includes sensitive information or information that, if disclosed, would injure international relations, national security, or national defense. That disclosure package will be redacted to protect that information pending this court's determination of what, if anything, can be disclosed and how it can be disclosed. The Canada Evidence Act provides the procedure to be followed, which leads to a designated judge reviewing the redacted information and hearing evidence about why it should remain redacted. The Attorney General will generally provide both public affidavits and secret affidavits. The party affected is obviously not provided with the redacted information, but can make submissions to the designated judge about why they believe the information that they have not yet seen is relevant. In addition, an amicus may be appointed to ensure that all relevant considerations are explored. The mandate given to an amicus may be tailored to the particular case. And if an amicus is appointed, up until the time that that amicus has access to the protected information, they may liaise with public counsel and get a good sense of the issues and why certain information may be relevant to that person, or to learn of the overall theory of the person affected. For example, the defense theory in a criminal prosecution. The amicus may challenge the Attorney General's claims that disclosure will be injurious and can make submission on any related legal issues that arise and on the balancing exercise to be conducted by the judge. In determining whether the information should remain protected, the court applies the test established in the Ribich case from 2003. First of all, whether the information is relevant to the underlying proceedings. Secondly, if relevant, whether its disclosure would be injurious to national security, national defense, or international relations. And third, if the information is both relevant and injurious, then the balancing is conducted to determine whether the public interest in disclosure outweighs the public interest in non-disclosure. And this balancing will depend on the context and the competing interests at stake. The court may determine that nothing be disclosed, or that everything be disclosed, or that summaries of the information be provided, or other conditions as warranted. Immigration is also a very large part of the federal court's jurisdiction, and some immigration matters require determination by designated judges. National security-related issues may arise in some cases, for example, the judicial review of decisions that an applicant is inadmissible to Canada on security grounds, which would include engaging in espionage, engaging in terrorism, or being a member of a criminal organization. Section 87 of the Immigration and Refugee Protection Act provides for the non-disclosure of parts of the certified tribunal record. The Minister of Immigration may bring a motion pursuant to Section 87 to protect that information from disclosure on the basis that it would be injurious to national security or would endanger the safety of any person. And where the motion is brought, a designated judge will review the matter and will determine whether disclosure would be injurious. Unlike the Canada Evidence Act applications, there's no test of relevance per se or any balancing. If the judge finds that disclosure of the information would be injurious, the information will remain redacted. Sometimes the information redacted is not of any consequence to the determination of the merits of the application. For example, it might involve just the names of third parties that should be protected or the description of administrative procedures. And often the Attorney General will clearly indicate that it will not be relying on the redacted information. And occasionally an applicant will consent to the Section 87 order. Other times, the assurances will not satisfy the applicant, and moreover, the determination is for the court to make. Section 87 motions may require the appointment of a special advocate to protect the interests of a foreign national or a permanent resident, but this does not occur in all cases. Our practice is also to ensure that the designated judge who determines the Section 87 motion remains seized of the application for judicial review. The Immigration and Refugee Protection Act also sets out the regime for security certificates, which garnered much attention after 9/11. I have not dealt with a judicial review of a security certificate, but I'm aware from the jurisprudence and from my colleagues' description that these are very complex matters requiring the review of volumes of information aided by the submissions of counsel for the Attorney General and special advocate or advocates. The court is required to ensure that the information that is injurious to national security is not released, but also to ensure that the person affected knows the case they have to meet. There are also a range of other matters determined by designated judges. For example, where a person has been listed on the no-fly list and seeks to have their name removed, a refusal decision by the minister may be appealed to the court pursuant to the Secure Air Travel Act. Similarly, appeals from cancellation or refusal to issue a passport pursuant to the Prevention of Terrorist Travel Act. Judicial reviews of decisions refusing to produce records and documents to a requester pursuant to the ATIP and Privacy Act are also dealt with by designated judges. The common feature in the judicial review or appeals of these and other decisions is that the information must be protected, and the determination of whether it should remain protected will require affidavits, some secret, and submissions generally in camera in order to ensure that the protection remains until a determination is made regarding the possible release. In conclusion, the role of the federal court in national security has evolved and expanded in a responsive way over the last 50 years to, among other things, the changing threat environment, the need to ensure respect for charter rights, the need to address access to justice, and the need to strike the right balance between the protection of certain information and the open court principle. Designated proceedings are usually closed, although we aim to do whatever is possible in public. We are all acutely aware that ex parte and in-camera proceedings demand the highest level of scrutiny. We're not a rubber stamp process for the applicant, who's usually the Attorney General of Canada. We probe and question and demand the information necessary to permit us to ensure that the requirements of the applicable regime have been met. For affiants and for counsel, we may appear to be difficult to satisfy because we are. We are increasingly releasing more public decisions with redactions as necessary to demonstrate the issues the court is addressing. This may raise the awareness that what is argued and decided behind closed doors reflects the judge's consideration of all the relevant factors. We know that just as the last 50 years have resulted in very significant changes to the nature of our work and how we do it, the next 50 will bring even faster paced changes. Thank you.
Thank you very much, Justice Kane, for this most interesting background information on the jurisdiction and the role of the court. I think it will come as a surprise to maybe a lot of our participants to understand the scope and the ambit of the role of the courts in national security matters. So thank you very much for that. Now we'll move on to the discussion between Professor Craig Forsisi and Mr. Gordon Cameron on a few topics, and that's, I think, where the questions will probably come up. So over to you, Mr. Forsisi and Cameron.
Thanks very much. Can I just do a sound check? Am I coming through clearly?
Yes.
Okay, wonderful. Thanks very much. Thanks for inviting me to this session. And I look forward to a conversation with my friend and colleague Gord on this important topic. Maybe though I should begin first with I'll call it a public service announcement, and second with a disclaimer. So the public service announcement, thank you very much, Justice de Montagnier, in terms of your generous words about my work as an academic. I'd also like to acknowledge the work of Michael Nesbitt at University of Calgary and Professor Leah West at the Norman Patterson School at Carleton, who are working in this area as well. And of course, Kent Roach at the University of Toronto. And my public service announcement is for those who may be on this call, academic colleagues who are interested in generating more courses in Canadian law schools on national security. We're always happy to hear from professors who are beginning that venture. My disclaimer is that while I'm here in my academic capacity as a co-editor of the 50th anniversary volume and as the author of the National Security chapter, I am also a member of the National Security Intelligence Review Agency, which of course performs a review function in national security. And so I speak solely in my academic capacity, and nothing I say today should be taken as reflecting the views of NCIRA. Today, Gord and I have set out a roadmap of sorts in terms of the topics we'd like to cover. And essentially they encompass two broad categories. The first is what I'll call the judicialization of intelligence. And the second is the complexity of the institutional challenges in the national security area. That complexity has already been alluded to by Justice Kane and Justice de Montagnier. And in discussing these topics, I thought maybe we could say a few things about both the past, the present, and the future of the federal court's role in national security. And of course, the future probably is the most interesting aspect because it allows us to make some observations about perhaps where we're heading. And then when I conclude my remarks, time permitting, I'll make an observation about what I'll call an enduring challenge. So what I'd like to do is just start first with this issue of judicialization of intelligence before turning the mic over to Gord, who will amplify some of my remarks. This phrase, judicialization of intelligence, which I quite like, I think first originated with the then CSIS director, Jim Judd, in the late 2000s. And I think it captures something we've heard already, that is the expanding role of the federal court. The federal court has been involved now in a greater area of activities, and the legalization of intelligence practices has continued apace through the last 20 years. And so there are now practices that once, not so long ago, would not have been nearly to the same degree within the shadow of the law, which are now carefully regulated by law. And often in the expansion of legal remit, the federal court has been drawn into largely into what we call the judicial control function. And so Justice Kane talked about warrants and warrantry, and Gord Cameron will expand on some of the issues there. And so turning to the past, present, and future of judicialization of intelligence, once upon a time, as Justice Kane suggested, when the CSIS Act was enacted, the judicial role, the judicial control role of the federal court was relatively limited. It was confined to Section 12 and Section 16 warrants. And in comparative terms, I imagine those warrants were rather simple. And we can talk about the change in technology in a few moments. The present, of course, is very different, as alluded to by Justice Kane. And that leads to an observation about where things are heading. That is the future. And so as intelligence becomes increasingly legalized, will we see a growing role for the federal court in the future? Will it be the place that Parliament turns when it begins to legalize more and more of the intelligence function? I think that's likely. And one area where I think we might see some thinking in the near future is the special challenge raised by what I'll call the one-size-fits-all Section 21 warrant provision in the CSIS Act. And so, as Justice Kane described, the federal court adjudicates whether warrants should issue. There's a single warrant process under Section 21, and that juxtaposed rather starkly with the system under the criminal code, where there are, shall I put it this way, different warrants for different circumstances. And so you find production orders, and you find intercept authorizations, and you find general warrants. There are different processes tied to different forms of invasive search and seizure. That's not true under the CSIS Act. And so one question I think which may emerge in the future is whether the Section 21 process has, whether it's still fit for purpose, and whether the warrant process should bifurcate in ways allowing lawful access powers to match the degree of intrusiveness associated with a given search or seizure. And so we'll wait and see if there is any action on that point. Now I'm going to pause because I know that Gord has some observations about warrantry that he wants to raise for our conversation today.
Thanks. To follow up on what Professor Farcisis said about the unique nature of Section 21 warrants, one thing that might not be immediately apparent to everybody considering this is that a CSIS warrant, a warrant under Section 21 of the CSIS Act, is fundamentally different in important ways from the type of search warrant or intercept warrant that the police or other law enforcement agencies are going to obtain. One of the most obvious differences is that the target of the warrant will almost certainly never know that they were a target. And that means there is not some subsequent forum, such as there is in a criminal prosecution, for anybody to challenge the appropriateness of the warrant having been issued. What this means is that the federal court, when it's deciding to issue a warrant, conducts appreciably more sophisticated and detailed analysis of the warrant, both in terms of the type of information it receives, and also it has a hearing before a judge with both affidavit and viva voce evidence, argument by counsel, which is, as I say, if you're familiar with the typical criminal law context, the process before the federal court involves a much more sophisticated pre-review before the issuance of the warrant. Another feature of a Section 21 warrant is that the information collected under the warrant can have almost endless impact in a variety of contexts that are very difficult to even imagine from the time the information is first collected, because the information is basically kept forever as opposed to being used for a particular prosecution and then binned. And similarly, it can be used, it can be shared with other agencies, domestic agencies, it can be shared with foreign agencies. It could pop up many years later when a person whose information was collected is in some completely different context, applying for a passport or security clearance or citizenship or whatever. And so it has a very long life in unpredictable ways, because it's not just even the service who might be using that information. The person could run into information that was collected under a CSIS warrant completely without their knowledge in some other country when the information's been shared with another agency. So the ramifications of the collection of this information are potentially much more serious than your typical criminal law warrant. And so one of the things you see at the issuance stage of a Section 21 warrant is much more stringent conditions on the subsequent use, retention, and use of the information through the use of conditions, destruction requirements, etc., because otherwise the information could just live forever and be used in almost any context. So if you understand that, those fundamental differences between the warrants, you'll appreciate how much work goes into, when a federal court judge is hearing a warrant application, how much work goes into both the Attorney General side application, perhaps an amicus's assistance to the judge in determining the matter, and the judge's assessment of the merits of the application. And one thing we're seeing now is the development of jurisprudence, Canadian jurisprudence, as the court has issued public reasons on a series over the last 5 or 8 years, a series of warrants, jurisprudence in which the court is articulating these points in a public way to try and open up the process so that the public has a greater appreciation of what's going on in these rather unique warrant situations.
Before we move on to the next topic, I'm wondering if I could put a question to both of you. In your initial comments, Professor Forsisi, you mentioned that there is a trend to judicialize national security matters. And I was wondering if that trend, if you know of whether this trend is noticeable in other countries as well, and whether it is something that is inevitable or not, or whether there are other ways to do it.
It's a great question, and I think the answer is unequivocally yes, especially in the Five Eyes community. So that would be the United States, United Kingdom, Australia, New Zealand, and Canada. Do you see, for example, in the United Kingdom, a move towards the judicialization quite literally, whereas before intercept warrants were authorized by the minister at the executive level, you now have judges rebranded as investigative commissioners who perform a role roughly analogous to the federal court, not just, by the way, in relation to warrants by the security service, MI6, but also by other entities within the broader security and intelligence community in the United Kingdom. And so that's a rather considerable evolution in the UK practice. And of course, in the United States, in the FISA context, the Foreign Intelligence Surveillance Act court, you have seen more and more jurisdiction being ascribed to that entity by virtue, frankly, of changing technology. And so the preoccupations are more than simply intercepting the content of communications now. Now we're also talking about intelligence services having access to what's known as metadata, information about communications, from which one can draw important inferences, sometimes inferences more important than even knowing what the content of the communication was about the conduct of individuals. And because of the nature of that intercept and because of the privacy implications of using that sort of information for law enforcement or intelligence purposes, you're seeing courts brought in and those courts asked to perform a task, sometimes directly analogous to conventional warrants, sometimes a little bit further afield, because of course, when you're intercepting bulk data or data on an undifferentiated basis and sweeping in a lot of incidental information, some of the conventions about warrants in terms of specificity and understanding the full implications of an intercept become much more difficult. And so you're seeing the law trying to grapple with technology, albeit always as a lagging indicator. That is, the law always struggles to keep up with technology. And it's raising all sorts of conundrums on the margins, some of which perhaps we can talk about. I hope that's responsive to your question.
Yes, thank you. Mr. Cameron, would you like to add anything on this?
Yes, I just add that Mr. Judd might have been bemoaning the judicialization of intelligence, but it has some obvious advantages to those of us interested in controlling the ambit of security intelligence investigations. And for example, there has developed, I think, a very healthy dialogue between CSIS, between the service and the Attorney General and the courts about what investigative powers they want to exercise that require warrants and what don't. And so in theory, the service doesn't need to consult the court on that, but it is a useful part of the dialogue for the judges to look at an application and say, well, this part of what you want to do requires a warrant because of the strictures of the charter, but this you won't. And in a number of recent cases, we've had amici in there arguing the point for warrants to be required in circumstances. Sometimes the court has agreed, sometimes the court has disagreed and allowed the service to collect the information without the warrant. And one of the reasons, one of the upshots of this is the federal court, the judges hearing warrant applications, are acutely concerned to ensure charter compliance, most obviously Section 8 charter compliance, with the issuance of warrants. And that's interesting because in almost all of the contexts in which the information will be used, there will be nobody challenging the charter compliance of the issuance of the warrant. The information sort of disappears into data banks and government reports. It doesn't surface in contexts where the people whose information it is get a chance to challenge its charter compliance. So the court has to be proactive on that. It has to take its own initiative, impose the legal analysis, sometimes with the assistance of the amicus and the Attorney General. And I don't want to even call this a spin-off benefit, because I think it's an important central benefit of this, is that information gathered by the service for its own purposes will sometimes end up in a criminal prosecution. It gets handed over by the service in accordance with the CSIS Act to some law enforcement agency in the course of either a terrorism or simply a criminal investigation. And it's critical at that stage, if it's going to be used as evidence in a criminal prosecution, that its collection meet the standards of the charter, or the criminal prosecution will fail, at least as regards that particular evidence. And it's not just that the criminal prosecution might fail, the reputation of the federal court as a defender of the charter would be harmed if the superior courts were observing that these warrants were being issued without acute sensitivity to the compliance with the charter. So in general, I see the judicialization of the collection of intelligence to have a lot of good benefits, as much as it might be seen as a constraint by the service on the freedom of their activities.
And I can assure you that all designated judges are well aware of these concerns, as Justice Kane, I'm sure, could testify to.
Yeah.
Thank you.
Maybe I could pick up the thread. I see that there's a question in the Q&A in terms of the challenge of having a set of facts upon which to adjudicate these questions, these complex questions about the scope of a given intercept technology, et cetera. And maybe what I'll try to do is weave a thought on that into the next portion of what I'd like to say today, and that's the complexity of the institutional challenges for conducting national security and for the function of the court. And really, I would say there are three developments in this space. There's what I'll call the changing national security accountability terrain, and I'll say a few words about that, because the federal court now occupies a specific space in that terrain, but there are a lot of other players. There's also the changing complexity of technology, which we've alluded to several times. And then finally, there's also the changing threat environment. Now, I'm not going to focus on threat environment, although we could have a conversation about that, the time permitting. What I really want to say at the outset is to focus on this question of the changing accountability framework. And so we have a number of accountability bodies that now are invested in what I'll call scrutiny of the security intelligence services. Once upon a time, and so here's my past, present, future analysis. Once upon a time, you had the federal court performing a judicial control function that is largely related to warrants for CSIS. And you had the Security Intelligence Review Committee, CIRC, who was the initial review body. And by review, I mean essentially ex post facto audit of the CSIS conduct to ensure it complies with propriety standards, legality and propriety. I don't want to put too much of an emphasis on ex post facto, but the idea is that you're looking at the conduct, you're auditing the conduct, rather than serving as an authorizing entity prior to the conduct of operations. Now, the terrain is much more complex. There's a chart that I prepared that you'll find in the e-binder that tries to subdivide the world of scrutiny, as well as what we would call not just scrutiny, but other forms of control. And you'll see that there are a lot of different players, and they have a variety of functions. Not least, we have now a proxy, I'll call it a proxy judicial control function performed by a new institution known as the Intelligence Commissioner. And so the Intelligence Commissioner performs a role that is at least roughly analogous to issuing a warrant. It's not, probably it's a poor analogy, in relation to the incidental collection of Canadian information by the Communications Security Establishment. We also have then review conducted no longer by CIRC, but by two bodies. We have a Committee of Parliamentarians, the National Security and Intelligence Committee of Parliamentarians, and we have the National Security and Intelligence Review Agency, who both have overlapping subject matter jurisdiction that extends to the entire national security and intelligence conduct of the Government of Canada. Meanwhile, the federal court control function has been expanded to include not just classic warrants for the purpose of security intelligence and foreign intelligence operations, but also something called threat reduction activity. And I think, I believe, Justice Kane, you mentioned this, where at least in principle, there are circumstances where the service will be obliged to seek federal court warrant prior to conducting that activity. We could talk more about that. And then there's also this new regime called data sets that were introduced in 2019, which allow the service to ingest electronic information contained in data sets that would otherwise be unretainable under the conventional rules in the CSIS Act. There, if the service is to retain what are known as Canadian data sets, they need authorization from the federal court. Now, you can imagine how technically complicated it might be to assess data sets. Gord's already mentioned the complexity associated with trying to figure out what collection activities might amount to with given technologies. Now we're talking about data sets. What do these mean? What do these developments mean for the future? Well, the interaction between these different accountability bodies and their sometimes separate, sometimes overlapping roles and functions, that interaction is imperfect. And there's the prospect of silos and blind spots. And so, for example, with one relatively minor exception, there is no way for the review bodies to communicate their classified findings to the federal court, even on matters directly implicating the federal court's judicial control functions. Instead, communication is done at best through the intermediary of the security services. And so it's not surprising in these circumstances that the federal court might be tempted to assume a more assertive post-warrant issuance role, that is by imposing conditions, and or might be inclined to signal specific issues in its decisions that then ignites a response from the review bodies, and or they might impose conditions in their warrants on reporting of review findings to the federal court. You can imagine the complexities that arise in those sorts of circumstances as the federal court tries to signal concerns to the review bodies through its decisions. Meanwhile, on the review body side, the review bodies for their part might wish to develop a system that both allows the court to push and signal concerns, perhaps by the federal court being encouraged or in the course of its decisions to signal a specific concern that arose in the course of a proceeding that the review body would not otherwise necessarily be alive to. And also the review bodies might be inclined to find a way to pull updates on developments at the court so that they understand what's happening at the court and can have a weather eye on those developments. Keep in mind, the review bodies are not confined to a record. And while the court is confined to a record before it, the review bodies can wander with greater latitude in conducting their review and may have a better sense as to the broader picture, but may not be alert to issues of concern that are arising in court proceedings. And so one of the challenges going forward in terms of this complicated accountability framework is finding ways to communicate across accountability bodies without triggering concerns about need to know and the sharing of classified information. So maybe I'll stop there and turn the mic over to Gord, who may have observations or amplifications.
Just on the latter point, Professor Arcis, I mean, we have seen some examples of the difficulty that the siloing has caused in recent situations where, for example, a judge will read in a CERC annual report that CERC is concerned about something and wonders if the federal court knows about it, and the judge will say, well, now I do, because I've read about it in the annual report. Or the judge will instruct the service to notify NCIRA of some set of facts, but then it's in the hands of the service to report it in its own terms, and the judge doesn't have a direct line of communication to say what he or she might be concerned about. So there's obviously gaps there. I wanted to pick up, if I could, on the Q&A that you mentioned earlier. There's a couple come in about one person asked about the difficulty of understanding what you and I are talking about when they don't have a fact situation because of all of the confidentiality of the material. And what I would suggest is that people who are interested in this check the federal court reports. The court over the last 5 or 8 years has done a great job of issuing public decisions on warrant applications and on other matters where you can, I mean, there are redactions and nobody likes redactions, but you can follow along and see specific examples. The Chief Justice did an important decision on the service's use of cell site simulators, those magic boxes that allow the service to imitate a cellular telephone antenna and capture information from nearby cell phones. And that's the investigative technique. And it had to be decided when warrants were required for that. And anybody reading that decision can follow along. There are redactions, but you can understand exactly what he's trying to say. He had a similar decision on the collection of identifying information from cell phone companies who from whom the service can get information about targets and stuff like that. So there is a body of jurisprudence. One thing that might make that more accessible is if the federal court website had a tab specifically for decisions in designated proceedings, because otherwise you have to sort of know what you're looking for or search the names of the designated judges or something like that to compile that body of law, or you have to buy Professor Facis's book on national security law and look at the footnotes there. So there is a relatively useful level of transparency. You can get a very good window into what the federal court is doing. You have to muscle through the redactions, but we're getting better and better. The amici, the attorney general, the judges are getting better and better at finding ways to communicate the substance of what they're talking about without disclosing the necessarily confidential information.
Maybe as Mr. Cameron has, I'll pick up on some of the questions before talking about the complexity challenge associated with technology. And Chief Justice Crampton, you've asked, what can the federal court do to increase the transparency of its work in this area? I'm actually going to applaud the federal court for how it's handled the question of redaction. So first of all, the federal court has committed to a practice, at least where novel legal issues are raised, of issuing its judgments. And so you do have now a corpus of case law on CSIS warrants that not so long ago would have been much more difficult to understand. And one of the notable aspects of the way that those decisions are released, yes, they're with redactions, but I've found very heartening and very useful the imposition in a redacted passage of a sanitized summary. That is just a statement as to what's been removed so that you understand the context. Because otherwise you remove a few nouns and a few verbs and there's no way you can possibly follow the chain of logic. And so the federal court has adopted this practice of inserting at least just a phrase. So the redaction could be of some sensitive technological means of collection, and the passage just is sensitive technological means of collection. And so you understand what's in that redaction. And I think this is a broader conversation about transparency in the national security sector, because redaction is always a challenge. It's especially a challenge because no one ever got fired for under-redacting, all right? Or rather over-redacting. So the incentive structure for redaction is in favor of redaction, not in terms of transparency. And so how do you overcome those sorts of impetuses within executive government and generally for the review bodies and others who are involved in trying to be as transparent as possible about their activities towards the broader public? Well, one of the things that probably we should all think about is how to write for maximum release. So sometimes you can make the most cogent observations without necessarily straying into classified information, and those classified aspects that might be necessary for an inside reader to understand could be embedded in a footnote. And so the footnote can be redacted, but the thrust of the key points in whatever's material from a legal perspective remains intact in the body of the decision itself. And so writing for release is a challenge for all of us, and it's probably a frontier challenge. I think it's an important challenge, in part because working on the civil society side of the House, those redactions sometimes are highly prejudicial to the reputation of the redactors, that is the institutions, the security services themselves, because as I often say, sometimes you might have a propensity to fill in the black redactions with whatever you wish. It's in the eyes of the beholder, and you can embrace whatever expectations you have about the service, and you can superimpose them in those redactions. In other words, conspiracy theories lie in the redactions. And so it's not actually useful for the broader credibility of the system sometimes to over-redact. And so I think it's incumbent on all of us to try to write for maximum release. Maybe now, having made that point, I could turn a little bit to the question of technological complexity, which we've talked about in passing. And I think the point has been made already, but I'll just amplify. Technology makes it much more difficult to understand the implications of warranted activities. And so in the past, it was largely an analog era. And so determining the impacts of a warrant for a landline, a wiretap on a landline, presumably that was fairly straightforward. you knew the location of the landline, you knew who might be using it. It's a much more constrained venture than what exists at present, because at present, it's the digital era, and determining the impact of a warrant for some sort of digital form of collection, and we talked already about metadata, could be much more complicated. Just to add to the complexity, and this now turns to the future, we're on the cusp of what everyone likes to talk about as the artificial intelligence era, or at the very least, machine learning. And as we all know, in terms of our understanding of how that works, we're talking about algorithms. The operation of those algorithms may be very difficult to understand, including understood by those who use them. In other words, the algorithms become the proverbial black box. You don't understand how they're generating their results. And so there's considerable worry, for example, about algorithmic bias. That is, if you train your machine learning algorithms on a data set that itself encompasses bias, that is, it's focused on a particular subset of data sources and it's not representative, the algorithm will learn the bias. And so trying to understand what given technologies and techniques might mean in terms of the broader compass of civil liberties issues is going to be an enormous challenge going forward for us all. And that then raises the issue about what that might mean for the court. So Mr. Cameron has already mentioned the issue of special advocates in amici, so too as Justice Montagnier and Justice Kane. Will the federal court find itself in a position where, on top of amici who are lawyers, will the federal court need a roster of technologists who will be able to provide independent advice and observation about new technologies that are emerging in this sector? And if so, how will that work? How will security clearance work? Is it possible to build a roster of technologists who are sufficiently independent of the services? Will they be precluded from their regular day jobs once they're privy to national security secrets? These are all issues that are in part playing out in the United States, where the FISA court, as I understand it, does have technologists who serve as amici, at least in part. And so I think that is a frontier issue for the courts in the area of technology. And let me pause there to see if Gord has observations.
Yes, I mean, I think the short answer to your question is plainly at some time in the future, the court is going to have to find some way of getting independent technological input. And it surfaces very acutely in recent cases where, as you say, it comes in both directions. On the one hand, the threat actors are using more sophisticated technology to do what they want to do, and the service is mobilizing more complex technical, investigative, and surveillance techniques, and the internet, computers. All of this involves technological issues that often go to the extent of the intrusiveness of the investigative technique sought. And that is very difficult to assess without good technical input, because if you only have one witness, and that is the witness of the service telling the court what the technology can do, what use can be made of information if it's compiled and put together with other information, et cetera, then the court's only getting one side of the story. And the no multiplication of special advocates or amici can solve that problem when the amici, like me, are lawyers, not computer programmers or IT specialists. And it's come up in several recent cases where we simply have had to do our own research on technological issues to try and cross-examine technical experts called by the service. So it's certainly open to the judge to ask for a witness, an independent witness, either appoint that witness themselves the way judges do in other cases, or ask the amicus to find a witness and call that witness. But as you said, Professor Farsis, the practical implications of getting that person security cleared and given the information and sworn to secrecy, et cetera, make it almost impossible, at least with the mechanisms we now have available to us, to get that information before the court, let alone get it before the court in the window that the court has to issue a warrant, because these warrants are often very time sensitive. The court has an obligation to be responsive to the service's need for these investigative techniques. Right? And that runs into another problem that I see has come up on the Q&As, which is the duty of candor. And the Attorney General has an obligation to present the court with the technical expertise necessary. This is part of their obligation on an ex parte application, and they recognize this, it's in the Attorney General's guidelines on the duty of candor. The witnesses that are presented to the court have to be knowledgeable about the issues that come before the court. And yet that hasn't always been the case on these technological issues, that the witnesses simply aren't prepared to answer the questions that arise on a technological basis. So part of what has to happen here, in part because it is so difficult for the court to get its own expertise, is for the Attorney General and the service to be more forthcoming in bringing the expertise before the court. At least then we can cross-examine it and the court has the opportunity to question the witnesses.
Maybe Justice Montagnier, I see that some questions have popped up, and maybe I can.
Yes, there are quite a few that I can see. Some you've already responded to or sort of responded to, but there are a few others. One by Ms. Smith with respect to the need for more diversity and the people dealing with these issues, both within the security service, and I gather from the other side as well, the judicial side and the amicus side. Do you have any comment to make on that?
Well, the first observation, Ms. Smith, I would point to the reports from 2 years ago, I believe, from the National Security and Intelligence Committee of Parliamentarians, which did a study on employment equity within the security sector, the federal security sector, so security intelligence community. Now, the employment equity is a slightly narrower ambit than what we, I think, mean by EDI right now. But at the very least, there's data in there and some observations I think that are very useful about how attuned the security services are to this issue. I would say that at the managerial level, based on that report and based on a podcast I did with some people from the security service, they are alive to these issues. I won't speak to the court. I will say that the review bodies are also alive to these issues, and in part because of the effect of security service activity and the perception of that activity amongst affected communities. So these are recurring issues, and diversity is not a perfect answer to these recurring issues, but it's certainly a necessary prerequisite to fully understanding the scope of these issues. At least that's my view. Maybe I could address the question posed by, I'm sorry, Justice de Montier. I'll let you jump in. The question that you posed, Ms. Laura, I'm sorry, I apologize if I'm mispronouncing your last name, is whether it's possible to be compliant with the charter while at the same time retaining confidential information from applicants, or at least maintaining if you're talking about a surveillance warrant, the prospect that the target is not fully apprised of the surveillance activity, because of course, if the target knew of the activity, then the purpose of the surveillance would fall away. So the challenge here, I think there are a couple of challenges in terms of charter compliance, at least from my perspective. The first is that when it comes to novel technology, and we've already made this point, the charter is always a lagging indicator. And so we don't have a rich case law. And what happens often is we have a new emerging technology. Parliament is relatively inert in terms of updating statutory law to reflect changing technology. And so matters percolate along, raising new privacy concerns that ultimately spill over to the courts. Most often they spill over into the criminal field because you've got a volume of cases, the deliberation, the adjudication is public. It ultimately arrives at the Supreme Court, and the Supreme Court lays down the expectations under Section 8 as to what the charter might require for, say, text messages, to give you an example. Up until that time, there's substantial uncertainty. And so the only way to resolve that uncertainty, frankly, is to adjudicate matters. And if the adjudication is taking place on the criminal side, and your answer comes on the criminal side, then you have to transpose the answer from the criminal side to the related but sometimes quite distinct world of security intelligence. And that itself can be a difficult exercise. So one of the problems, it seems to me, of charter compliance in this space is uncertainty. There's a substantial amount of uncertainty. And my preference, speaking personally, would be to see more proactive efforts by Parliament to grapple with questions of legal reform through statutory mechanisms in a way that announces its approach on lawful access before it's adjudicated in a very idiosyncratic way, perhaps by the courts. And so we've seen that more on the criminal law side, where we see this proliferation of different sorts of authorizations, but we have not seen it on the national security side. And so for me, a big issue of charter compliance is uncertainty. The other dilemma, the dilemma of confirming charter compliance while at the same time having an ex parte proceeding in which the target is not represented is always going to be a challenge. And I think Mr. Cameron laid out how important it is, therefore, to have a robust warrantry process that involves, where necessary, amici and special advocates, but also the federal court in a slightly different role than would be the case for a court at the criminal level. The court at the criminal level there's always a more serious prospect that an intercept authorization will be challenged were the matter to arrive in criminal court through a Garofoli. It's less likely to occur on the security intelligence side. So there will always be a need for the federal court to be quite assertive in this space to align the privacy interests of the target and the charter interests with the necessary ex parte nature of these proceedings. Maybe I'll stop there.
If I can just add, Professor Versis, to your answer to Ms. LaRue's question, I think that, as you say, there is always going to be a compromise of due process when a person affected by national security litigation is simply not allowed into the room to represent their interests. And so we have special advocates that the Supreme Court, I think, quite correctly realized were a necessary part of some proceedings, and we have amici and other proceedings. You mentioned the involvement of amici in warrantry, and that's important. In that context, though, the special advocate is often representing the public interest generally when some investigative technique is under review. Sometimes there'll be a specific named target of the warrant, but it's also often just, in principle, are certain investigative techniques too intrusive. But in many of the situations where amici and special advocates are appointed, there actually is a person who can't be represented by their own lawyer in the room. And the system does as the best job it can in that context to have the amicus communicate with the lawyer for the affected person, learn how to best represent that person's interests in the closed proceeding. The court then does everything it can to communicate whatever goes on in the closed proceeding to that person who's affected by the proceeding, and ultimately to issue reasons for decision that hopefully give that person the best possible insight into the reasons for the decision, positive or negative. So it is never, as long as you are dealing with information that affects a person's rights that they're not allowed to see, it is going to be a compromise. But through the techniques that have been developed since the Sharkawi decision of the Supreme Court of Canada, it is better than you might expect. I mean, I think counsel on the outside who have to deal with special advocates and amici usually have a pretty good idea of what's going on inside and are usually relatively satisfied that the interests are being adequately protected.
One of the issues that came up is whether the amici are at a disadvantage when arguing a case because they don't have access to all the non-redacted versions of other cases that may have implications in their own case. Do you see that as a real issue?
Well, it is certainly a real issue to some extent, because I've been on maybe now 40 of these cases. I have some grasp of a lot of the jurisprudence, but it is a serious problem because you are up against Attorney General's counsel. They not only have access to all of the decisions in their unredacted forms, they can, as a group, sit around the boardroom table, strategize on individual cases, make strategies overall for their approach to a topic or an area of jurisprudence, etc. The amici are all lone wolves. They're acting on their own. They're prevented from talking about their case to other amici because they have the constraint on communication. So they, read the public versions of the decisions, try to find out as much as they can, but there's a definite disadvantage. Another thing, while I'm whining about the plight of the amicus, which is that the amicus is almost completely unsupported in his or her work. And I'll say or her, that's not just a token observation. There are, to the comment about white male participants in this process, the last two amici who have been appointed to accompany me on cases have not been, they've been female and not white. So there is movement on that. But the amici have to do the best they can to try and marshal the information they have. But it's a definite disadvantage, both the lack of access to jurisprudence and the lack of ability to consult amongst each other about best strategies.
Professor Forsizi, would you like to comment on the question asked by Aidan Campbell with respect to the advent of NSI COP and NSIRA and the changing role of the federal court as a result?
Yeah, so I mean, it's hard for me to comment on how the federal court perceives the changing environment and whether it's changed the nature of your work. I will say that so they do have discrete functions. So as compared, say, to the United Kingdom system that I mentioned before with these judicial commissioners, the system there, the judicial commissioner will issue the equivalent of a warrant, and then they have at least I don't want to call it rudimentary, but at least a prospect of their technical folks reaching in post-warrants to assess the, not compliance necessarily, but exactly what happened. And so once the warrant leaves the room, there's follow-on that exists in their infrastructure. So they've bridged both what I'll call the judicial control function and then what I'll call the review function to a degree. They have different challenges in consequence. Our system, as I've suggested, is the federal court issues the warrant. What's the subsequent role of the federal court once the warrant is issued? And one can debate that. But the visibility as to what happens with the warrant really lies with the review body. And so in a system that was self-reinforcing, where there was a virtuous circle, there would be a capacity, as I've suggested, for the review bodies to report back to the court. So the court has full knowledge as to how a given authorization really played out in the real world. There are limits on the resources available to the review body. The review bodies can't possibly review every warrant. And so there has to be some way to do a triage on which warrants would be reviewed. But I think we're left, as Mr. Cameron suggested, with a system where the review bodies communicate with the court either because the court has issued an instruction in the course of its warrant authorization that a given review be supplied to it in unredacted form, or the service itself decides that it will do so, or the review body issues its public version, and CIRA, for example, is now moved to a policy of issuing redacted versions of the actual reviews, not just the summary in its annual report. There's always a lag because of the redaction process. But of course, how much can you really learn from the redacted version? It's often difficult. And so the degree of granularity or resolution from that process, I think, remains a challenge. I don't think I can go any further in terms of what it looks like from the federal court side.
I think you mentioned earlier that you would be speaking to the changing nature of the threat. That might be another topic of interest, I think, to many of us. I'm not sure if this is a proper moment to get into this.
Sure, I could say a few words about that, subject to the caveat that I don't purport to be a specialist in this area. I just make a few observations. If you'll forgive me, maybe I could also address Justice Pentney's observations or questions in the chat box as well. And so, Justice Pentney, you've noted that in relation to judicialization, you see two trend lines: the shift from warrants allowing passive monitoring to judicial approvals for more active measures. I think the starkest drawing line between these 2 points is probably your conventional Section 21, Section 12 investigation collection activity versus the prospect of a warrant seeking authorization to engage in a threat reduction measure. And we haven't talked much about that, but maybe I'll just use this opportunity to say a few words about some of the challenges in that space. So when it comes to threat reduction measures, so the service is entitled to take steps proportional to the need to reduce threats to the security of Canada. And in circumstances where those steps would violate Canadian law or limit the Charter, there's an obligation to first seek a warrant from the court. And this was introduced in 2015, amended in 2019 to further limit the sorts of activities that the service can undertake under warrant. But it's a categorically different exercise, or at least in principle, a categorically different exercise to issue a threat reduction warrant than a surveillance or collection warrant. Why? Because you're talking about a whole host of activities that may touch on any number of different Canadian laws and may touch on any number of different charter rights. So you're not talking strictly about a Section 8 analysis anymore. And the court is left to anticipate exactly how things may play out on the ground once the warrant walks out the door. And so there isn't any precedent or analogy that naturally comes to mind for such an authorization process. I'll add one last observation. What's the threshold for seeking a warrant in the first place? Well, the threshold is, would it limit a charter right or would it violate a Canadian law? And so if there's uncertainty about what steps violate what law or what the charter really requires, then there might be doubt as to whether one needs a warrant in the first place. And so the federal court has never given an opportunity, if the decision is made that no warrant is required, to weigh in on those issues of charter compliance and condition the activity. And so there's a whole bunch of uncertainties in relation to threat reduction measures that are, in terms of my analysis, past, present, future, lie in the future. Justice de Montigny, you asked me to say a few words about threats. Maybe I'll just make an observation and we can play with it. So the last 20 years have been about anti-terrorism and post 9/11. So anti-terrorism presents its own dilemmas in terms of security intelligence. It presents its own dilemmas in terms of collection activities. Of course, we've since seen a shift in terms of the threat environment, and we now speak about foreign interference. We speak about interference in economic activities, so economic security. We talk about espionage, all of which engage perhaps some of the same legal issues from an intercept or collection perspective, but take place in a very different context. And so the shifting terrain in terms of threat preoccupations may change the color and nature of the sort of activity that percolates up to the federal court. And then in terms of frontier issues, so what does cyber mean? So the preoccupations with cyber. How is cyber going to play out in terms of an ongoing threat issue, and what legal issues does it raise? And this is a little bit out of the federal court's bailiwick, but when you start talking about the conduct and activities of the Communications Security Establishment and its expanded remit since 2019, and the role of the Intelligence Commissioner in terms of approving on a reasonableness threshold at least classes of activities that the CSE may engage in terms of foreign intelligence collection and also cybersecurity and information assurance. How will the Intelligence Commissioner's role evolve? And are we going to have a conversation about perhaps different approaches by the Intelligence Commissioner to, say, questions of international law versus the approach that the federal court has taken on questions of international law? And how do we reconcile those? And so I think the changing threat environment will necessarily precipitate unusual and different legal issues as we go forward.
So Cameron, would you like to add anything on this?
No, I don't have anything to add on that, but I see that Professor West has posed a follow-up question to some comments I was making before, where she has asked about the consideration of having, in effect, a permanent amicus, and she asks, has that ever been given serious consideration? I know that it was given serious consideration by Sylvia McKenzie, the former senior legal officer with the federal court, and I don't know if anything's come of it, but that is an example, having some form of special counsel, you might call it, in a permanent position. I do know that when the special advocates were being coordinated by Mr. Wilkins, by Keith Wilkins, he did as much as he could to arrange for databases of decisions and communication, getting special leave for communication among the special advocates. But I think that is Professor West's comment about a permanent legal officer in the amicus position is a good proposal for a solution to the difficulty of communicating among amici and corporate knowledge and institutional memory about all the things that have gone on in other cases.
Justice Kane, would you have anything to say about that?
Well, I think it would require a great deal of thought to sort of flesh out what the implications might be of that person, who it could be quite an isolating role if you were the in-house amici. It would almost it could lead to some concerns that that person starts to think a certain way. And we have a wonderful roster of amici who come before us, and they're not always on the same, obviously they're not on the same case. You might see them on a few cases over a course of a year, but we have that variety. So I think that gives the person whose interests are needing to be protected and who aren't present some confidence that they've got an independent set of legal eyes in the courtroom as well. And I don't know if that would be the same if you had an in-house amici, but if it were more in the nature of a support function for the amici, that might be different. So it's certainly worthy of some consideration. But I'm sure there are lots of implications that my colleagues would come up with that I can't on the spur of the moment, but we will give it some thought.
There's another question maybe that would be best directed to you, Justice Keynes, from Barbara Jackman, the last one that shows. Would you want to say something about that?
Sure. The question is about whether the court has a sort of a view against appointing special advocates in Section 87 motions. And I would say definitely not. I mean, the Immigration and Refugee Protection Act provides that a special advocate may be appointed, but not all Section 87 motions warrant that. So there'd be a range of considerations, including the nature of what's redacted. If it's a few words here and there, then it may not require a special advocate to weigh in on those issues. As I mentioned, this is a determination that the court has to make about whether the redacted information would be injurious. We have appointed special advocates for Section 87 motions in the past, and I'm sure we will in the future where it's warranted. So a range of considerations, but we certainly don't rule it out. It's there, and it needs to be relied on to protect the interests of those persons in the appropriate circumstances.
Thank you. We've got about 3 minutes for both of you, Mr. Forsisi and Cameron, to wrap up. I don't know how you'd like to do that, but...
Sure. Maybe I could just make an observation about what I call the enduring challenge, something that hasn't changed and probably never will change, because it represents a hard dilemma that I think needs to be in existence. And so, as I've suggested, and as we've discussed, the last 20 years have really been about the federal court reconciling the open court concept and the rule of law with the much more closed, by necessity closed, aspects of the national security apparatus, working through special advocates, amici, redacted decisions, as well as, I would add, some of the jurisprudence the federal court has developed on some of the secrecy doctrines. So things like originator control and mosaic effect. All that has been embellished and evolved considerably in the last 20 years. On the other hand, I think, as Mr. Cameron has suggested, the tension between the open court function of the federal court and its role in performing judicial control and the often bona fide concerns of the security services in terms of confidentiality cannot really fully be reconciled. I actually consider it a healthy tension, but is unequivocally a tension. And so, having authored the piece in the 50th anniversary book on the federal court and national security, and having had the privilege of interacting with many judges, I will just make one final point about some of the challenges for the federal court going forward for the next 50 years. There is always a challenge, it seems to me, for judges who operate in isolation and somewhat siloed in their national security work, much so, more so it seems to me, that even in their regular judging work. And so the challenge, it seems to me, for a designated judge is to address the often serious nature of national security proceedings with an unrelenting embrace of the rule of law. And so the judge is obliged to maintain a conscientious effort to provide perspective and distance. And we heard about, Justice Kane, you mentioned the seriousness with which the judges embrace this role. And with so much of this court's national security function occurring behind closed doors, it will rarely be evident to the public whether the court has succeeded in maintaining this perspective. And so one of the challenges for the court going forward, I think events like this are really important, but so too continuing efforts to produce redacted versions of a jurisprudence so that we don't end up with a series of principles being applied by the court that are available only to the court, and potentially not even available to amici as they come and go, depending on the files they're working on. And I will say, based on the interviews that I've had the privilege of running over the last few years, that judges are clearly conscious of these concerns and also conscious of the generational shift in the pool of designated judges. And so as it begins its next 50 years, it's clear to me that the court has embraced the challenge of maintaining an institutional knowledge of the sort gained, especially over the last 2 decades of national security work. And so I'll end my comments there.
Mr. Cameron?
I'll just add very briefly an endorsement of what Professor Farsis has said and highlight the point about the fact that the court has developed this really good body of jurisprudence on warrantry and other national security situations, and whatever work can be done by the court, by academics, to preserve that. We know that there are a number of judges who've been very active in this area who are either already supernumerary or are retiring. Ms. McKenzie, a well of institutional memory, has retired. So we need to find ways of preserving that jurisprudence and other institutional memory aids to make sure that the next 50 years takes advantage of the past.
Thank you. And on behalf of all of the participants, I would like to thank our 3 presenters for their most interesting thoughts on these very complex issues. Je pense que vous avez réussi à démystifier un monde qui est pour la plupart des citoyens canadiens très complexe, très opaque. We hope that you have enjoyed this very brief glimpse into the work of the courts and matters of national security. And we will present one final webinar that will address the issues of intellectual property on December 10th. So I hope, and you have the advertisement for this, so I hope you will join us on December 10th for this 4th and last webinar. Thank you very much, everybody, for your participation.